accessibility. So when everybody is able to come up with amazing solutions, is for the betterment of the larger community, not just the fintech, it's the betterment for the customers, for investors, for governments, for the economy in general. It helps to improve efficiency, builds trust, expands opportunities, and just helps to also boost competition. When there's, it is essentially like it promotes like a capitalist approach. So when everybody is trying to get the next big solution, it helps to provide customers with more options, drives competition, and basically enhances your efficiency and provides opportunities for both investors, for customers, and the economy in general. So I'll be highlighting the key IP rights that you have under that fintechs should typically look at. You have your patents, you have your copyrights, you have your trademarks, you have your trade secrets. So I primarily focus on trademarks in my own brand to protect their brand, essentially protect their presence in the market, their logos, their catchphrases, things that are related to their presence in the market. But I can also touch on patents, copyrights, and trade secrets. So your patents will essentially help you protect inventions. So it doesn't necessarily have to be something grand, as long as it's an inventive process. Your patents help you to protect that. Your copyrights would help you protect software code, designs, documentation, things that under literary works for copyrights. That's what your copyrights will essentially help you to protect. Trademarks, like I said, brand names, logos, product names, service marks, essentially. And then your trade secrets help you to protect. These are information that you do not essentially want the public to know, but then there are things that help your business to thrive. So it's algorithms, data models, customer analytics, surveys that you might have taken, but you have to make sure that all of this is done by the book. So it's information that that gives you a competitive edge in the market, but you do not want anybody to essentially know about it. But this is legal in Nigeria, but there's no particularly any framework for that. So I'll touch on that when I expand on each right. So patents in fintech, essentially inventive processes that make the entire fintech system easier. So patents are essentially protected by the Patents and Designs Act. When you have an inventive process, once you meet the criteria for registrability for a patent, you essentially approach the Patents and Designs Registry, and you get 20 years of protection under the patent rights that you are granted. And it's also contingent on you paying your annuities every year to make sure that that patent is maintained with the registry. So the challenge with patents in Nigeria is that there's a very strict criteria that the registry puts on what can be patented. So you might think, oh, what you've invented might fall under patent registration, and by the time you get to the registry, they might tell you that it doesn't meet the requirements for it to be patented at the registry. So that's just the downside of that. But once it meets the criteria, you get, and you cannot always license it out to other people to use. It also gives you the right to, if you see somebody that is you can basically challenge on the grounds that you have a patent registered, and as long as it is properly maintained by paying your annuities every year. So the next one we have is copyright. It protects your software code. So certain things that might not fall under patents, you can use copyright to have them protected, like your software code, the UI, UX interface that you put on the products, the designs and whatnot. These are things that you can also put under copyright, under literary work, under artistic work. The Nigerian Copyright Act protects copyright, and the advantage essentially is that you immediately get protection as soon as it's created. You don't need to go ahead to do any further registration. Registration is at your own discretion. If you feel maybe you need to register with the Nigeria Copyright Commission, that's fine. But once the product has been undertaken and it has come into life, it's no longer an idea, it's now something that you can see is automatically copyrighted. So one thing that fintechs typically need to look out for is that when you employ people or you engage people to help you build, for example, you build like a user interface, write software code for your apps, for your websites and whatnot, there needs to be clauses in the service agreement or the employment states that any intellectual property that they are creating under this particular contract or this engagement would automatically fall under the ownership of the fintech company. Because once you create something that is copyrightable, it goes automatically to the author, except there's a contract to the contrary that states that, okay, the author, all the economic and moral rights attached to this particular work would be transferred to the fintech company. So that's one thing that fintech owners need. Once you're engaging somebody to create user interfaces for you, write source codes for you and whatnot, create APIs, you need to have this thing. You need to have a contract in place that essentially transfers this ownership from the contract, the person that's creating on your behalf, to the company. And then we have trademarks. Trademarks essentially help you to protect your brand name, your logos, your catchphrases, your slogans and whatnot. It's important because it helps to build brand trust. Like once people see your logo or your name on something, it creates some form of trust in the market. So there in Nigeria, the trademarks are registrable at the Nigerian Trademarks Registry and protected under the Nigerian Trademarks Act. We have 45 classes of trademarks, and essentially the classes that touch on financial services, touch on banking, touch on any area that involves your fintech, you should ensure that you have registrations undertaken in those classes. However, what I typically advise clients to do is you can register across all classes to make sure that there's proper protection, to make sure that you're fully protected, because somebody else can decide to use your goodwill in the market, and what they will say is, oh, you don't have it registered in this class, in the same class, you have it registered in another class. And it becomes harder to more or less challenge such form of infringement. Then the last one we have here is trade secrets. Essentially, these are things that give you a competitive edge over your competitors in the market. It's your algorithms, your customer analytics, your spreadsheets and whatnot. And while there's no legal framework for the protection of trade secrets in Nigeria, we have them protected through contract law. You have your non-disclosure agreements, you have your confidentiality, because you have your employment contracts as well you need to put confidentiality clauses in these contracts or in these service agreements that you have with persons working for the fintech, stating that they cannot divulge any information that they may have received during the undertaking this instruction on your behalf. So whilst you cannot particularly sue them for trade secrets specifically, you can sue them for breach of contract and ask for damages from the court. So I just highlighted some of the key laws and regulators for fintech IP in Nigeria. You have the Copyright Act and the Nigerian Copyright Commission. Protects software code, literary works, algorithms, digital content. This one's fall under literary works, artistic works. You have your Patents and Designs Act that covers invention and industrial designs. However, like I said, software patenting is limited because some of them do not necessarily meet the criteria for patentability at the registry. Then you have the Trademarks Act and the Trademarks Registry. Protects your brand names, logos, your slogans, and whatnot. Then you also have the Nigeria Data Protection Act. So essentially, if you are going to be using, for example, under the trade secrets, now you're going to be using customer data, customer analytics for, let's say, your AI models, your machine learning and whatnot, you need to essentially make sure that this personal data that you are getting has been properly gotten in accordance with the Data Protection Act. So that one also covers IP in Nigeria. Then you have the National Office for Technology Acquisition and Promotion Act. So this is when, for example, if you are licensing or acquiring technology from outside the country, basically regulates cross-border acquisition and licensing of foreign technology. So practical IP strategies for fintechs. Typically you need to conduct IP audits regularly, make sure that all the different forms of IP you have in your operations are properly protected, be it patent, be it a copyright, be it a trademark, be it trade secrets, make sure that everything is properly protected. Then you can file for multi-layered protection. You don't need to restrict yourself if it's patentable and also you do both. And then also you need to secure licensing agreement. So for example, if you're making use of let's say a source code that might open you up to liability, you need to essentially have your licensing agreements in place to make sure that okay, whatever source code you're using for this project has been properly gotten. You need to probably get representations and warranties from the person that is licensing these things out to you, stating that they have the right to own, that they own this IP to start with. They have the right to license it to you, and that they are not breaching any laws by taking this license process to you. Then, like I said, use confidentiality and employment agreements generally. So that's for your trade secrets, anything you do not want the general public knowing that gives you an edge in the market, you need to have them properly protected under your employment contracts, under NDAs, under confidentiality clauses in service agreements. So the challenges in protecting IP, fintech IP, essentially in Nigeria, I would say, I don't think Nigeria has probably evolved properly to make sure that they are protecting IP at the rate at which it is advancing. For example, with the fact that you can't patent software code. So there's a rapid pace of innovation, and I just think the laws we have are not enough. They don't properly offer protection to IP owners. And the thing with IP is that it can be very, very territorial. So if you have it registered outside Nigeria, you're trying to enforce it can be very hard. So because there's somebody else that can have it also registered in Nigeria. It's a first come, first serve kind of thing. So where you're primarily operating it, you need to make sure that it's registered there. There's also the issue of cybersecurity risk and data leaks. So essentially, if you're dealing with personal data, customer data, there's the possibility of these things of you being hacked and whatnot, and then you breach your obligations under the Nigeria Data Protection Act, under the Nigerian Constitution, like privacy and whatnot. And then the cost of protection. While startups might see it as something that they do not need to do, or they do not need to, that I would always very many advice that you do at the beginning of your operations. Make sure you have everything you need to trademark, have it trademarked, everything you need to patent, have it patented, tie up all loose ends with your employment contracts, with your NDAs. Make sure that all of these things are in place, because even if you go ahead to move forward and then you run into problems in the future, let's say the patents you've used are infringing on the processes you used are infringing on somebody else's patent rights. You just lose your liability. Or you've probably, let's say all the money you've been able to raise in your series funding will probably now go to settling lawsuits with the person that are bringing infringement matters against you. So I have some case studies here. At the international stage, we have the Apple Pay and patent dispute. So this essentially involved a lot of patent owners coming and saying that most of the processes undertaken, that they used to generate or create the Apple Pay process infringed on their patent rights. So apart from just even doing an IP audit, you need to do your due diligence, whatever you're creating, make sure that it's not infringing on somebody's rights. It doesn't open you up to liabilities. And then on the Nigerian front, we have the Paystack versus Zap Africa with respect to the Zap trademark. Paystack still alleges that they undertook their due diligence in the necessary class and states that, oh, they did their search to make sure that the mark was not registered in a particular class. However, the trademark searches are not that hard to undertake. Once you get to the trademark registry, you can do a blind search for as low as 100,000 across all classes. So it's something that could have been avoided by just undertaking a simple search. So, like I said at the beginning, you need to always protect your IP. It's a very critical asset in your fintech growth. You should also approach the protection with a multi-pronged strategy. Basically, if it falls under patents, falls under trademarks, make sure you do both. And then you must balance innovation with legal safeguards to make sure you open yourselves to liabilities at a future date. So thank you very much for listening in.
All right, thank you so much, Mr. Adedamola, for your presentation. It was very wonderful. All right, so we'll be getting back to you later on, a bit later on in class. We just want to hear from the other mentors, hear from the mentees, and then, we'll call you back on to share some feedbacks based off of the presentations that will be made. So we have Mr. Max in class. Thank you so much, sir, for joining. We are happy to have you. Yes, sir. So please, we also want to just hear from you in today's class. Share your thoughts.
Okay, yeah, thank you, Dennis, and good afternoon, everyone. It's a pleasure to be back in class again this week. Let me also thank Mr. Adedamola, the mentor who just spoke before me, for a very concise but very incisive presentation that largely covered the full spectrum of IP protection for fintechs. I'll just add a few thoughts and just a few other issues that I think is worth having in mind when you think of intellectual property with respect to fintech products. I also try to be careful to remember that not everyone in this cohort is very familiar with IP, even though I believe Mr. Adedamola has done a great job in explaining the basic IP or IP types, the basics of IP itself in terms of what IP is and how you can relate it to protection of fintech products. So I'll just start off by pointing out the strategic importance of intellectual property to fintech. From Mr. Damola's presentation, you'd see that intellectual property really protects, property other than tangible property. So we know that for a traditional business, their main asset class that generates money for them is usually their physical property. So, for instance, a company like Dangote Cement makes its money primarily from the cement plant, the physical cement plant he has that converts limestone and gypsum into cement bags, and then they sell and make money. But if you think of a company like a fintech, for instance, like Paystack or Flutterwave, for instance, they do not make money from necessarily any physical process. And that is why you'll be surprised when you go to those fintech companies and see what their head office looks like. It might just be largely not a very big building, and then most of their team members work remotely. Some of their people are working from Australia, others are in Canada, and all of that. That is because what they are selling is a service, and the real deal of what spins money for them is not something physical or tangible like a cement factory that you can hold and touch, but rather it is a systems, the processes, the technologies that they have put in place that spends that money for them. So the lesson from that is that when it comes particularly to fintechs, sometimes the real asset that would make them be able to raise financing is their portfolio of intellectual property. That becomes the collateral in that sense that makes anybody want to put money into a fintech. So I mean, if somebody or if Dangote Petroleum Refinery, for instance, is trying to raise maybe funding, trying to raise $2 billion US. Of course, largely the collateral that will be backing up that transaction would be, the physical plant that they have. But if a fintech, is trying to raise money, I mean, if you're a prudent business person and you're putting money into any business, you are hoping that if there is problem and my money cannot come out, I need to have a fallback, a collateral, something I can hold and sell off. So for most fintechs, what funders, venture capitalists, private equity players, bank on when they put their money in is really the portfolio of intellectual property that fintech owns, starting with a brand, more in depth, of course, Mr. Adamola's presentation made it clear the brand, of course, will be protected, by trademark. That would be things like the name, the logo, and then, of course, you look at things like the algorithms, the software, the codes running the software, which are largely protected by copyright, and then, of course, innovative aspects of the product and the service, which will be protected by patent. So largely, this would be the things that a potential investor is eyeing when he's putting his money into the fintech, knowing that if the worst case scenario happens and they have to fall back on liquidating that fintech to get their money out, then that the sales of those intellectual property assets is what would justify a return on their investment. So therefore, it's important that in advising a fintech, that you advise them to periodically do IP audit. The IP audit is to help them assess which intellectual properties they have or they have created in the course of their business. Then, of course, the next stage is to ensure that those intellectual property rights are protected. So the ones that need to be registered are registered. The ones that need to be renewed, for instance, a patent has to be, you have to pay what they call an annuity, yearly payment that keeps that patent active. Trademarks, for instance, when you register them in the first instance, you are protected for 7 years under Nigerian law, and subsequently, you can renew them for periods of 14 years indefinitely. So you need to be sure that you're advising your fintech client to keep protecting, registering their trademark, and ensuring that it's protected. So there have been disaster scenarios, for instance, where this might not be a pure IP issue, but for a fintech, for instance, letting your domain name lapse, for instance, is a huge issue, because there have been disaster scenarios where companies allow their domain name to lapse and forgot to renew, and then somebody else hijacked that domain name and will now insist that before it returns the domain name to the company, they have to pay an amount that is way, 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 way above, the amount that the person spent reserving or buying that domain name. So these are scenarios. I mean, also another area where it plays out is maybe a new top-level domain system is opened, and the fintech has not gone to reserve its domain name in that top-level domain. So let me explain what a top-level domain is. I'm sure we all know it, but just in case of anyone who doesn't know it. So the last part of a domain name is what we call the top-level domain. So there are different top-level domains. There's .com, which is the most popular and really should mean .commercial, really for commercial agencies. Then there are so many others. We have .org, which is for organizations. We have government-related domains like in Nigeria, .gov.ng or .gov.edu for educational institutions, who get that domain layer. But we should understand that there was a time where there was like a democratization of the domain name system, and then it became possible to create all kinds of top-level domains, using the International Corporation for Assigned Names and Numbers, which is like an organization that manages the internet domain name system. So that is why now you can have new types of domains. You can see a domain extension like .london, .lawyer, and all of that. So, for a fintech who is perhaps maybe a legal tech startup, and they had registered their domain name, say everlaw.com, and then there's a new domain name extension that is now .lawyer. It will be prime for them to go there and register, their company, their everlaw.lawyer, because that website would relate to the kind of business they do. But if they have not done that and somebody else does it, then they run into a problem. Now, one of the ways they can solve that problem is a system called, managed by the World Intellectual Property Organization, and in collaboration with the ICANN I mentioned, that's the Internet Corporation for Assigned Names and Numbers. So it's called the Uniform Domain Dispute Resolution Policy. What it does is that if you can show that you have evidence of trademark rights in a name and somebody else goes to register that name as a domain name, then you can go to that UDRP proceedings, and it's kind of an accelerated arbitration process that takes usually 2 to 3 months maximum, where you can get an order directing the registrar of that domain name to transfer the domain name to you. So, sorry, I know this might sound complex, but let me just break it down. So, and maybe I'll use a live scenario between two fintechs or, players in the technology space in Nigeria. So, what happened was that when Jumia, of course, we know that Jumia, has a history from somewhere, German partners, formed that company, and then they started coming around, and they came to Nigeria to set up in Nigeria. So when they set up in Nigeria, they had approached a young man called Simdul Shagaya, who is the owner, who later became the owner of Konga. But at that time, they approached him to partner with them to start up Jumia in Nigeria. And I think he gave it some thought, and after a while, he said, "No, I won't join you guys." And they started off. And shortly after, he started Konga, which was also an e-commerce platform at the time, and started poaching some of the workers from Jumia. So Jumia was a little unhappy about that. Jumia also became aware that at some point, Konga was planning to expand outside of Nigeria to other African countries. So part of what Jumia decided to do, maybe just to spite and to limit the ability of Konga to use its popular brand name Konga when it goes outside of Nigeria, was that they went to those countries and registered the domain name for Konga in the top level domains of those countries. So, for instance, in Kenya, that would be registering konga.co. I think Kenya is KN or KY or so. That's their own country level domain. So by doing that, it would mean that if somebody in Kenya now sees the konga.co.ky domain, they would assume, oh, that is the Konga, the big e-commerce giant from Nigeria, launching in Kenya, not knowing that it is Jumia who is essentially controlling that domain name. So Konga was, of course, furious and went to the WIPO UDRP to try to get that domain back, to say, look, we are the owner of, we are popularly, we are the owners of the popular Konga brand name. So we have the right to have that domain transferred to us. But unfortunately, they lost that case. And that was because at that time, the Nigerian Trademark Registry had a lot of backlogs and delayed processing of trademark applications. So even though Konga had applied for the Konga trademark to be registered, at that time, they only had the acceptance, the acknowledgement, and the acceptance from the Trademark Registry. They did not yet have the trademark registration certificate. So when they went to the UDRP, they could not prove their trademark right, because the way you prove your trademark right at the UDRP proceedings is to tender your trademark certificate, but they did not have, I mean, of course, there are other ways. I'm just giving a high-level illustration. There are other ways you can prove you own a brand without necessarily producing a trademark certificate, but the primary and the easiest way is to produce your trademark certificate. But unfortunately, they were not able to do that, and because of that, they lost that case, and therefore it meant that they were not able to control that website or that domain name in the Kenyan market. So this just tells you the importance, of intellectual property to a fintech that wants to grow and expand and go across borders. There are a few other case studies. I won't go into them in depth, but one of them is for those of you who I'm sure you should know at least BlackBerry. BlackBerry, of course, was the rave when mobile communication really picked off. That was really the first harbingers. I mean, before them we had mobile phones, but not really mobile communications in that robust sense. So we used to have the Nokias of the world in those days, who had the basic GSM telephony, but not the very robust internet connectivity that we now have on mobile devices. But BlackBerry was the first, the pioneer in that industry. I mean, of course, people know though that Obama winning the 2008 US presidential elections, one of the critical success factors to his election victory was really the BlackBerry platform that gave him that robust ability to be able to communicate, with particularly the younger voters in the US at the time. So I'm just saying that BlackBerry was a big deal. But BlackBerry as a company, had a head start on Apple, on Samsung, and on any of the other companies we currently see as giants in the mobile telecoms world. But they lost that edge, and we currently have completely fallen into demise because of a lack of proper strategy towards their IP protection. What happened in the BlackBerry issue was simply this, was that when BlackBerry started up, what we now popularly know as chats, the technology behind chatting, where 2 or 3 devices can communicate over the internet, that basic technology was really one of the basis of the BlackBerry technology. But unfortunately for them, another company called NTP already had a patent registered on, text communications over an internet network. So that company brought a case against BlackBerry, and for some reason, BlackBerry felt maybe these guys were not serious enough and didn't take the case serious and kept dragging over the case. But the more they dragged over the case, and the more the BlackBerry platform became popular, the more the valuable the demand or the claim made by that company. So initially, when the case started, BlackBerry could easily have settled that case for about $2 million US. But because they kept dragging, ultimately, when it became clear to them that if they did not settle that case, the company was going to get an injunction to restrain them from using that technology in their phones. By that time, they had to ultimately settle, I believe, not too sure now, but I think they settled for almost $4 billion US. So you can imagine how much they lost just because they did not do proper intellectual property due diligence. And in Mr. Adedapo's presentation, he spoke about that fact that when you are developing your software, you have to do diligence and find out, ensure you have licensing for any technology you are incorporating into your solution. Otherwise, the owner of that technology who you did not license can come and make a claim or get an injunction that you're infringing on his patent or his intellectual property, and it can stop you from using, from putting your product in the market. And of course, sometimes they'll do it when, at the time that it's most inconvenient. You're about to launch your new product and you have already mass produced the product. You have put a lot of money into the marketing drive and all that. And then suddenly there's a court injunction stopping you from launching that product. And you can see how much you would lose in terms of money and time. So that is why doing your IP audit, your IP due diligence is crucially important. Otherwise, you can run into troubles. So I think I'll just end at this point, and then during the engagement session, we can discuss more deeply. So Dennis, thank you, and back to you.
All right, thank you so much, Mr. Max, for your thoughts that you shared in class. It was very, very insightful. We were able to pick significantly quite a lot from your shared thoughts. Thank you so much once again, Mr. Max. So we are done with our mentors. Our mentors, in I think about 40 minutes, have done well to put us through some of the key concepts and ideas of IP protection of fintech. So we want to hear from the mentees, just like it's redo, to get your own perspective based off of your research. And based off of your research, we want to hear you also share your thoughts on the topic. So please, if we have the group presenter for group 1 and group 2 in class, we'll be taking your presentation now. Please, you have 15 minutes each for your presentation. Let's try to stick to time so that we don't overshoot on our time. So group presenter for group 1, if you're ready, the floor is yours. You can start your presentation. Do we have the presenter for group 1 in class?
Yeah. Good afternoon, Sam. Here, I'm trying to share my screen for the presentation.
Oh, all right. Please do. You can just do that and go ahead.
Yeah. Okay, please, I want to confirm if everybody can see my screen.
Yes, we can see your screen.
Okay, you can see the topic, right? Like, you can see the slide of, like, you can see the presentation slide.
Yeah, we can.
All right. Okay, so my name is David Okechukwu Kamsiyochukwu, and I'm representing the group 1 on the topic navigating the IP landscape in fintech and the strategies for protection and innovation. So, first of all, I'd like to take an introduction rather into what IP fintech or fintech IP means. So, by definition, fintech IP refers to the legal protection of creative developments and innovations at the intersection of finance and technology. So in the course of this presentation, I'll be highlighting certain key topics, which includes understanding fintech intellectual property, as I've already explained, giving an overview, the eligible innovations for fintech protection, for IP protection in fintech, the IP toolkits, which are patents, trademarks, copyrights, case studies of successful IP strategies, challenges in fintech IP protection, which we have jurisdictional complexity, regulatory uncertainty. Then I'll talk about IP protection and open innovation. Lastly, before the conclusion, IP infringement and patent trolls. So first of all, we have the key areas of eligibility. That is the concepts or the aspects of a fintech innovation that is eligible for IP protection. The first we have is algorithms, and they include the mathematical processes and logic, right? And the algorithms can get both patent IP protection and copyright IP protection. Where an algorithm is subject to copyright protection, it is usually required to be expressed in human or computer language, and it is protected, therefore, against copying and reproduction. Among other fintech innovations eligible for IP protection, we have software and source code. We have the business methods, which can also be referred to as the innovative core or the invention core. We have user interface, which is UI. We have data structures and security protocols. Now down to the fintech IP toolkit. Under it, we have the different classes of IP protection. We have the patents, we have trademarks, we have copyright, and we have trade secrets. So basically, patents exist to protect novel, non-obvious, and useful inventions. Please, I need to confirm if everybody's following with me.
Yes, we are.
Okay, am I too fast?
Your pace is fine.
Okay, so like I said, patents, they protect novel and non-obvious inventions. And in fintech, what it does is protecting new trading algorithms as well as blockchain mechanisms. Furthermore, patents grant exclusive rights to an inventor or a company for specific innovations, and it prevents others from selling, reproducing, or using the patented technology without permission from the fintech inventor or company. Secondly, we have trademarks. So basically, trademarks protect brand identities, and in fintech, it protects the brand identity of the fintech. For instance, the logo, the slogans and all of that. So those are trademarks basically protects those things that makes a brand stand out, and most of the times the brand identity conveys or carries with it the brand goodwill. So basically trademarks sort of provide protects the goodwill of a company as well from being exploited by another. Then we have copyrights. Basically copyrights protect original works of authorships, and in fintech it protects rather software source code, user manuals, and databases. And copyright protection has a duration of the life of the author plus 70 years. That is, where if the author, for instance, lives for 70 years or lives for 65 years, the copyright protection afforded to his fintech innovation lives about 70 years after. So if he lives for 65 years, for instance, the copyright protection afforded is 135 years. Lastly, we have trade secrets. Basically, trade secrets protect confidential information that provides a competitive edge for a company. So the basic requirements for trade secret protection is that these secrets, these information which are deemed confidential must be kept confidential. So provided they are kept confidential, the protection afforded is indefinite, as the what is it called? Just as it is here in the presentation slide, it says duration is indefinite as long as secrecy is maintained. Now down to the case studies. There are several case studies, but for the purpose of time, we have to work with two case studies. The first is the Paystack versus Zap Africa. So this case study basically has at its core the issue of first to file and the resulting potential for customer confusion in the market. Now, the essence or why this case study matters in fintech is that a registered trademark provides a legally defensible right, which is crucial in a rapidly growing competitive fintech ecosystem. And the lesson for fintech companies to pick is that proactive registration, comprehensive filing, and enforcement of IP rights is very essential in the rapid growing world. Like we've also listened from the mentors, owners of fintech innovations do not have to sleep on their rights. So they must always do their due diligence. And in as much as they've done due diligence before registration or before copywriting, before patenting, they have to still keep following up for whatever new trend that arises. And possibly they should get an IP attorney for advice, for legal advice on what's next to adopt in their IP protection. Then the second case study we have is system specs / remitter and government contracts. The essence of this case study is that the essence and lesson businesses in the fintech industry are to pick is ownership and licensing terms must be defined. In every fintech innovation, it is important that in as much as fintech adopts open innovation in order to grow, in order to develop these innovations most of the time, it is important that ownership, the extent to which a company or the extent to which a contributor or an inventor or a co-inventor in a fintech innovation has ownership should be clearly defined to avoid any issue of disputes over who has IP rights over a particular part and what's not. Having looked at the case studies, I'll go into the second part of my presentation, which is challenges in fintech IP protection. So basically, the challenges in fintech IP protection, that is fintech intellectual property protection, are divided broadly into two. We have the jurisdictional complexities and we have the regulatory uncertainty. So the first, which is jurisdictional complexities, on the start notes, we have fintech is inherently global, but IP rights are territorial. And for this, now we have an instance where an innovation protected in the US is not automatically protected in Asia. And this is one area from which disputes may arise in a fintech IP protection. Because, for instance, having known that an innovation protected in the US is not automatically protected in Asia, it would give a situation whereby a person in Asia, for instance, may use another person's innovation, having found about it, and it may be a lot of stress, maybe a lot of going through a lot of processes in order to gain remedy. And funny enough, the person who has already exploited has profited. So furthermore, on jurisdictional complexities, we have filing patents and trademarks across multiple jurisdictions is expensive and time consuming. Secondly, enforcement across borders is difficult and it requires local action. And lastly, fintech operates in heavily regulated areas. And these are areas such as banking, finance, data privacy. So the stress, how do I put it? The complexities surrounding registration of fintech IP protection is very high, considering the fact that fintech, which is financial technology, is usually, it centers around very regulated areas, which are banking, finance, and data privacy. And I believe these areas are very well or heavily regulated because of the cruciality that has to do with anything involving finance, anything involving people's money. And then lastly, we have regulatory uncertainty. Now, basically, regulatory uncertainty means the rapid shifts in regulations. So it means that the owner of a fintech IP rights must always follow up. And most times it could be a very daunting process to follow up with the latest law, with the latest regulation on fintech and all what's not, particularly on the global stage. And this can suddenly affect the viability and defensibility of an IP asset. Because you can imagine where, because a fintech innovator is unaware of a new regulation on IP or a new regulation on fintech, he could lose out because the courts would agree or pass a judgment that he slept on his rights or he failed to do his due diligence, whereas this was caused as a result of the rapid shift in regulation, which he may not have noticed. So therefore, the strategy to remedy the challenges in fintech IP protection, as provided in this presentation slide, is to prioritize key markets for IP protection and use non-disclosure contracts for global collaborations, therefore making it easier to adopt with the jurisdictional complexities in order to reduce the stress on remedying the challenges and complexities with ensuring IP protection across various territorial boundaries. Now, we have balancing IP protection with open innovation. Basically, balancing it will involve strategic licensing for specific use while making peripheral tools open source, contributing selectively, that is utility functions and proprietary functions, leveraging collaboration for growth while safeguarding fundamental competitive advantage. So what it means is, in as much as fintech companies or fintech inventors come together to collaborate for growth, they should still safeguard their fundamental competitive advantage, which is by ensuring that they clearly define ownership rights in order to ensure that each person is gaining or benefiting to the extent to which he contributed to the fintech innovation. Now, the emerging risks. On the emerging risks, we have two major emerging risks. We have infringements of fintech IP and patent trolls. One very possible infringement emerging risk is the rapid duplication of software. We also have the rise of patent trolls. That is, entities that will acquire patents not to use the technology, but solely to sue companies for infringement or extract licensing fees. We also have fintech vulnerability. This is because fintech is a very lucrative sector. So most persons, hackers, should I put it, people who are involved in illicit activities have fintech as their very prime target because of the amount, the volume of finances, the volume of money that passes through the fintech industry. Finally, we have the mitigation strategies. Some of the mitigation strategies includes preemptive filing. This is that fintech companies and fintech inventors should ensure to file strong, specific patents to secure their freedom to operate. Patent pools and alliances, collaborating with industry peers in order to share or cross-license patterns defensively. In conclusion, the following are strategies for success in fintech IP protection. The first is adopting a layered approach to IP protection. Secondly, think global, act local. This means fintech companies or inventors should prioritize protection in key markets and manage jurisdictional complexity with a clear intentional filing strategy. Also, IP awareness in NDAs and employee contracts should be fostered. And lastly, proactive defense. It is important that fintech companies and inventors regularly conduct IP, that is intellectual property audits, and prepare for potential infringements or troll attacks in order to avoid being taken unawares. So at this point, I've come to the end of this presentation. Thank you very much, everybody, for listening. Over to you, sir.
Okay, thank you so much, Ichuku, for your presentation. And well done to you and to your team members for putting it together. Yeah, I will just say well done. So we will be taking Group 2's presentation quickly, and we will be going back to our mentors. Group 2 presenter, if you're ready, we are also ready for you. Do we have the presenter for Group 2 in class? If the presenter is not around, can we have the backup presenter? Or just anyone within the group who can take the presentation? If you need help sharing the slides, I can work on that on my own end.
Good afternoon, sir.
Yes, good afternoon, Mebunat. All right, so would you need help with your slides?
Yes, please.
All right, give me a minute. Let me do that. Okay, sorry, it's taking quite a while. The slides are taking a bit of time to load from my own end. Okay, sorry, still having that issue. All right, please go ahead and introduce yourself. Your slides will be coming up now.
Good afternoon, everybody. My name is Memonat Olawore, and I am the group leader for Group 2. Okay, thank you. I can see it now. So our presentation today focuses on strategies for effective intellectual property protection in fintech, and we'll also touch on future trends and considerations shaping how fintech companies safeguard their innovations. Can I confirm I'm being heard, please?
Yes, we can hear you.
Okay. So this slide, we're going to be talking about what fintech intellectual property means. So fintech intellectual property refers to the digital assets that drive innovation. We have things like algorithms, software, mobile apps, payment system, and even brand elements such as logos and user interfaces. So these are the backbone of financial technology innovation. So unlike traditional intellectual property, fintech IP is mostly digital and software-based, which makes it harder to protect. And that is why having a solid intellectual property strategy is crucial. Next slide, please. So why intellectual property protection matters? The fintech industry moves very fast, and without intellectual property protection, even the most groundbreaking idea can be copied overnight. So intellectual property protection gives company a competitive edge, attracts investors, and help them grow sustainably. For example, in Nigeria, a fintech startup developing a mobile payment solution like Paystack or Flutterwave needs intellectual property protection to prevent competitors from replicating their code or their brand. The next slide, please. So what are the strategies for effective IP protection? So I'll be breaking this into two. It is building an intellectual property portfolio, one, and the second is tailored IP strategies by business stage. So the first one, building an intellectual property portfolio. The first step is identifying all valuable assets. Then you classify them under patents, like the mentors have explained to us the type or the classifications of intellectual properties. So we have to identify all valuable assets, then classify them under patents, trademark, copyright, and trade secrets. Then after, we assess the ones that are most important to the business and we focus resources there. So the second part is tailored IP strategies by business stage. Can you please go to the next slide? Thank you. A startup won't have the same intellectual property need as a large institution. So new companies might focus more on trademark and trade secrets, while established firms invest heavily in patents. So in the next slide, we're going to be talking about collaboration and consortiums. In Nigerian fintech space, collaboration is key. No company can handle regulatory and security challenges alone. So what is consortium? A consortium is basically an alliance where fintechs, banks, and tech firms, sometimes even competitors, come together to solve shared problems or challenges like creating payment system or security protocols. So why does this matter? Consortium help intellectual property collectively. Members share patents, they pool funds for legal defenses, and also build stronger standards together. An example would be, for example, instead of one small startup struggling with a patent lawsuit, 20 firms can unite to defend themselves effectively. We are stronger together than alone. Smart tools for intellectual property protection.
Sorry, it's on which slide? Sorry, just to cut in.
Okay. Sorry. Slide. I'm having problem trying to see what exact slide it is.
Just carry on. Don't worry. Don't worry about that.
Can you press on the next slide, please? Thank you. Yes. So smart tools for intellectual property protection. We have defensive publications, IP licenses, and cross-licensing. So what is defensive publication? They make an idea public to prevent others from patenting it later, and they are cheaper than patents. We have IP licensing. This helps companies earn money by allowing others to use their intellectual property for a fee or royalty. And we have cross-licensing. Here, two companies exchange patent rights to avoid lawsuits, and it is common in payments processing and security tech. So the next slide is talking about future trends and consideration. Thank you. The fintech world is changing fast, and intellectual property strategies must evolve, with emerging technologies. So the emerging technologies include blockchain, artificial intelligence, quantum computing, big data. The next slide talks about evolving regulatory framework. Regulation is one of the biggest challenges for fintech, especially in Nigeria, where multiple regulators like the Central Bank of Nigeria, the Securities and Exchange Commission, the Nigeria Communication Commission oversee the sector. So compliance with data protection laws, such as Nigerian Data Protection Act, is key. And there are also differences in software patent laws across countries. So fintech space must have an idea of that. And there is also the importance of maintaining cybersecurity. Next slide, please. Next slide. Okay, global solution for global business. Since fintech operates globally, most fintech operates globally, companies must understand international intellectual property framework, such as the TRIPS, the Paris Convention, the World Intellectual Property Organization systems. So this understanding helps with cross-border filings and harmonization, although enforcement still depends on the national laws. The next slide talks about conclusion and recommendations. To summarize, effective intellectual property protection is essential for fintech success. Nigeria fintechs must adapt to emerging technologies, collaborate through consortiums, comply with regulations, and think globally while acting locally. So part of the recommendations is to first adopt hybrid intellectual property strategies, to leverage partnership and consortium because we are stronger together and not alone. To stay regulatory compliant, here we need lawyers and compliance officers, invest in emerging tech protection, and lastly, to think global and act local. Thank you very much. Our presentation talked about strategies for effective intellectual property protection in fintech.
All right, thank you very much, Memunat, for stepping in to present on behalf of your group. Well done to you and to the members of the team that put it together. Job well done. So we will be going back to our mentors. We have received presentation from both Group 1 and Group 2. So we will be heading back to Mr. Ade Damola. We want to hear your thoughts based off of the presentations that was sent to you and overall they are discussed in class, what you thought about it, what you think they can improve on, and if there are any other thoughts you feel they might have missed in the presentation that you would like to highlight and share. We want to get your thoughts on that, sir.
All right. Thank you to everyone that presented. I would say the presentations were very insightful. They touched on every single thing that I would typically require them to highlight, from the types of IP that can be identified in fintech to the means of protection available to them, protection strategies. I think there was a presentation that had some case studies there as well. So I think all in all, they were very, very insightful presentations from both groups. At this point, I don't think there'll be anything I will need to add, given that the other mentor, Mr. Marks, also talked on domain names and whatnot. Maybe if they had included that in their presentations, that have been a properly broad and wholesome presentation. But all in all, it's very insightful, touched on the basics, and I love the use of case studies in it. Thank you.
All right, thank you so much, Mr. Adedamola. Mr. Max, if you're with us, we also want to get your own thoughts and feedback.
Yeah, thank you, Dennis. So let me commend both teams. I thought those were really very well put together. In fact, the slides, first of all, I really was happy with the quality of the slides. I thought they were really good visually, and then even in terms of the content as well. So kudos to both teams for a job well done. And I also like the fact that even though they were concise and even your presentation was very concise, but you were able to cover a lot of ground and also at some significant level of depth as well. So not like I have anything much to add, but just to highlight some of the things already discussed in both presentations. So both presentations touched on a very topical issue when it comes particularly to IP for fintechs, which is the question of how to protect software from an IP perspective. It's a touchy question. And Group 1 was right when you said, yes, that there's kind of a shared mix between copyright and patent protection when it comes to software. So even in the IP world, it's still a hotly debated problem, in fact, even in the advanced countries of the world, because initially the thinking was that software particularly was abstract and therefore software could not be protected as patent. But because to an extent, coding or source code, which is the expression of an algorithm, that's the way, okay, let me track back a little. Let's start with algorithm. So what we need to understand is that particularly from an IP point of view, an algorithm essentially is a set of rules or the logic or the sequence of operations needed to solve a problem. So an algorithm is as simple as, so for instance, we can say, what is the algorithm to lock the door of your room? So the first step or the first sequence to solve that problem of locking the door of the room is to walk to the door, push the door. The second step is to push the door. Third step is to turn the knob. Fourth step is to wait for a latching sound. And then fifth step is to turn the key clockwise, 180 degrees. You see that's kind of a set of rules or a sequence that tells you how to solve a particular problem. So that's the algorithm. But how to implement that algorithm in terms of in a computer now, you have to translate those set of rules into machine readable language using one of the coding languages. So of course, we know there are different coding languages, Python, C++, and all of that. So how you now convert that into language that a computer can appreciate is now the source code or the coding part of it. So it is from that level now that we begin to understand the separation when it comes to protecting via IP. Now, the source code itself is an expression. It means that if you bring two different coders to convert that algorithm, the steps I gave on how to lock a door, for instance, into computer language by coding, each person will come up with his own different expression, his own unique way of writing that code, because of course one person is using Python, or that's using C++, another person is using another programming language. So when we go back to now look at what IP protects, different kinds of IP, you see that copyright protects expression. That means if I express my idea in a unique way, no one else should be allowed to copy that expression of the idea. So of course, in its primary sense, it covers things like literary works. That means if I write a novel or a poem, then nobody else should be able to copy the exact words I used to set that poem or that novel. And then, so in that sense, you can see that when a coder is implementing an algorithm in coding language, is doing what is akin to what a poet or a novelist is doing when he's writing a novel. So that's why copyright protects that aspect of it. So that's the least controversial part of IP protection for software. The source code and all the coding part of the work is easily protected by copyright. But where there's now confusion is the algorithm itself. That is because the source code in ways how the thing works. How it is expressed, how your solution is expressed. But the issue now is how do you protect how it works? So, for instance, if I'm the first person who ever came up with the algorithm of how to lock a door, then the question is, I want to make sure that nobody, because I mean, I've done a lot of research and development to come up with that unique way to solve a technical problem, and I don't want anybody else to copy it. So how do I protect myself? Normally, in other areas, I would simply use patent. So, simple example, a patent essentially is a monopoly given by the government to prevent anybody else from using an invention. An invention we can simply define as a solution or a new solution to a technical problem. So in the world that we live in, there are all kinds of technical problems. So for instance, heat in a room is a technical problem. So the person who invented the air conditioning, would be entitled to a patent because he solved a technical problem by a new and innovative way of using what they call those using gas exchange to cool a room. So you give him a patent for that. So, but when it comes to software, it becomes more difficult because most patent law says that abstract ideas like formulas cannot be protected by patent. So, because of that, in the early days of the computer, most countries refuse to give patent protection to software products. So, over the years, it has evolved in some countries, and I'm also touching on part of what Group 2 spoke about when you also mentioned this issue of patentability of software. So what some countries have done is to now create a set of rules, what they call computer implemented inventions. So if an algorithm or even a software falls into a computer implemented invention, then you can protect it by patent. Unfortunately, countries like Nigeria, we are still arguing whether or not our law actually allows patenting of software. So we are not yet clear on that. So it's still an issue that leaves a lot of gap here or there. So one of the solutions, which I'm happy both groups touched on, is to use hybrid models. So for instance, trade secrets is one of the ways you can protect your software products, even if you are not able to get a patent protection for them as well. So I just thought to add some of these things to say, yes, both groups have done a great job, and that yes, you have raised what is actually a very topical issue, which is particularly patent protection in software. It's not an easy question to answer. It's always a complex problem, but like you recommended, it's important that fintechs always understand how to use a hybrid way to ensure that they get protection, even if they are not able to outrightly get patent protection. So thanks again to both groups. I commend you for a job well done. Dennis, back to you.
All right, thank you so much, Mr. Marks. Thank you for your shared thoughts and ideas, and you helping to clear some air as to the regards of patenting software, as regards copyright within software. So thank you so much, Mr. Marks. For the mentees, I hope you were able to pick up 18 or 2 from the shared thoughts of both mentors and including the presentation. You always have access to this class as it's being streamed. So if you need to revisit the class, in order to get, let me use the word meat out of the session, please feel free to always do that. Right. So we're almost at the end of this class. So, but like it's in our practice, let's take questions. So if you have questions, both Mr. Adidamola and Mr. Marks are available to address questions right about now. So we'll take questions quickly, and then, we'll move on to call it a day. So questions, anyone? All right, okay, please, you can unmute and ask your question.
Okay, good afternoon, everyone. I hope you can hear me.
Yes, we can hear you.
So my question is, where the where the software in question, right, is built by the founders themselves. So they didn't outsource the building. They didn't get anybody to work on the software. So the founders built it themselves, right? And most times they usually build it before they even get to incorporate the company. So my question now is, okay, so it's not a work for hire because it's their own company. When the company is now incorporated, right, they have to transfer the IP to the company for investor due diligence and all that stuff. So in my opinion, the best document to use for that is an intellectual property assignment agreement. But where my question lies now is that because the business is just starting, the company, the fintech is just starting, right? The founders who are the assigners of this IP, they are also the principal officers of the company. So they sign any contract on behalf of the company, but this agreement now transferring the IP from them to the company was done by them. So they are supposed to sign the IPAA, and the company too has to sign as well. So what happens in that situation where they have to sign on behalf of themselves and also have to sign on behalf of the company? Or is there any other practice, that any other routes that can be taken to transfer the IP from the founders who built the software to the company? And again, another part of my question is, where the founders transfer this intellectual property in this software that they built to the company, what sort of protection, what sort of clauses, how can they protect themselves? Because now they built this thing, was their original idea, but in order to pass investor due diligence and all that, they have now moved it to the company. But what is left for them? Do they move the entirety of their IP to the company? What can they fall back on? So yes, thank you. That's my question.
All right,
Dennis,
thank you.
can I take that question?
Yes, sir, you can go ahead and take that question.
Okay, thank you. Yeah, thank you, Uge. I mean, your question actually raises very practical issues. This is a problem that, in fact, I think just last month was something I had to still do some. I think last month I had to do some work on this same problem. You know, at the foundation of it, it raises the. So your first question actually is the easier part to answer, which is the issue of conflict of interest and corporate personality, because you are saying when the founders have to transfer their IP to the company, you know, how do they sign, since they are also the directors of the company? So that's very simple. The law is very clear that where, you know, that the company is separate, that the company is separate from the owners. So therefore, when the directors are acting as directors, that means you do an agreement, and I have done that in practice, where you go to the signature column and the signature says signed common seal of the company XYZ Limited, hereby affixed in the presence of director, and the two directors sign. And then you now go to the column where you say the company seal of the transferor, which the person transferring his IP right. It will still be the same director who still sign transferring his right as well. Just that in one part, he's signing as a director of the company, the other part is signing as his individual self. Typically, in those agreements also, there would be a waiver. One of the clauses usually at the end will say that there's a waiver of conflict of interest, that the parties recognize that the opposing parties to this transaction, you know, are one and the same set of people, and that, you know, the transaction has done at arm's length basis, and any conflict of interest has been agreed to be waived. So usually that sorts out the problem of any potential conflict of interest in the same set of persons doing the transfer, and also acknowledging the transfer on behalf of the company. Now, but the deeper questions that arise from your question, and which is the more practical issue we see on a day-to-day basis, is that when co-founders start up a company, they are all pitching ideas. Everybody just dumping ideas, you know, at the same time, and all of that idea becomes the business model that company is built on. So one person gave a part of the source code, the other person gave the algorithm, the other person, you know, did the actual writing, somebody did the reviewing and all. And then at that point, you cannot really tell who contributed what. And some companies actually start that way and continue without it ever really being defined who contributed what. And the time comes where maybe one of the co-founders, like the practical case I had recently, one of the co-founders abandoned the company. And it's a popular thing, even if you have watched the movie of Facebook, with Zuckerberg and his friends. And some of the founders just abandoned the company. I felt this company is not going anywhere, or they had finished NYC. The parents said, look, leave this your fanciful project, come and go for masters in the UK, and the person leaves. And the other founder continues to work hard at the company. And then suddenly, he's able to get venture capitalists interested, and then maybe the company closes an early funding round of 500,000 US dollars. And suddenly, the partner who abandoned the company just remembers that, I'm also a co-owner of this company. So where's my share now that the company is doing well? And then, an argument ensues. But you abandoned the company, and he says, no, but my part of the IP in the company belongs to me. So you have to buy me out or pay me off. And, and the argument becomes, if we are going to buy you out, we'll buy you out at the value as at the date you abandoned the company. Because as at the date you abandoned the company, there was no 500 US dollars invested in the company. The value of the company then was maybe just 10 million naira, what only the few things we had put together. But the guy is going to be arguing that, no, give me based on the valuation currently, now that the company has 500,000 US dollars. So that those arguments go back and forth. So to avoid all of that, that is why one of the things we tell founders is that you must have a co-founders agreement where all these things should be spelled out clearly. Who owns what? And then also it's important that in that co-founders agreement, that all the parties jointly agree to release all their intellectual property and transfer it to the company, so that even if there's going to be a fight between the co-founders, let the fight not affect the IP and the company itself. I mean, typically when investors come in, they would always insist on that before we put our money into the company, let's ensure that all of you have transferred your IP to the company, and that the company will not be bugged by any internal wrangling or civil war between you guys. So that's also a safety mechanism for investors as well. So a co-founders agreement is always advised. Then to the last part of your question, which is how would they be protected having given up all their IP rights to the company? How do they still get protection? So that is where you need to now have what we call your cap table, where you guys have already agreed on your equity. Sometimes you can also agree on what we call a vesting schedule, where you agree that fine, potentially for all the ideas and all the work that you have done as a co-founder, you potentially owe X% of the company. So you have maybe 20% or 30% equity in the company. But for your sweat equity, that means all the work you have done up to the point where that agreement was done and the company was formed, automatically 15% of your 30% is already vested. But the remaining 15% will be vested over maybe 4 years, along with other criteria. For instance, your performance of certain tax and obligations for the company. So that if the person abandons the company, for instance, at some point, and at that point, he had only done part of his work, he would get his 15% guaranteed, and then maybe an additional 5% based on maybe he had spent an additional 1 year before abandoning the company. That way, even if anything goes wrong, and then also coupled with that also is that you add the clause I mentioned, which is that if anybody abandoned the company, then the valuation of his equity or his shares, would be done based on the value of the company at the time he abandoned the company. So that if somebody abandons the company and comes back later, he will only be, even his 15% equity will be adjusted in value to only be 15% as at the time he abandoned, not 15% as at the current valuation of the company that has been grown by the sweat of the other people. So you can see it's a complex problem, but that is why having a co-founders agreement helps from early on to sort out all these issues and keep all the parties, within a proper balance. So, and one last thought before I go. Also, sometimes we advise founders that when you have your IP in a company, it is always good to note your IP as individuals before you transfer them to the company. In one area of IP law, this is very important, in copyright. So for instance, source code that I mentioned. Now, the way copyright works is that the protection in copyright, is not always uniform. It varies. So the standard protection, length of duration of protection in copyright is the lifetime of the author of that copyright work and 70 years after he dies. So for instance, Chinua Achebe, who wrote Things Fall Apart, I believe he died in 2012. So it means that 70 years after, till 2082, the copyright in Things Fall Apart is protected. You can't take that work and make photocopies and start selling it. But if copyright work is produced by a corporation, like a company, then it only has protection for 50 years from when the work is published. So you can see that if, as founders of a company, they choose to note their copyright to have been produced by the company, not the individual people before assigning to the company, they would only get protection for 50 years. But if they note it as produced by the founders or the individual team members and then assigned to the company, they can get the lifetime of the last living person amongst them and 70 years afterwards. So for instance, practical example, if you go to look at any of the patents, this doesn't apply to patents, this is copyright purely, but because of that practice, tech people always register their IP in their names for assigned to their company. So if you go to Apple, for instance, and you check almost all their patents, you will see that Steve Jobs is listed as one of the inventors. I mean, that's when he was alive. And then other team members individually before there's an assignment of that IP to the company. That also ensures that that's also another way to protect the founders, that the fact that your name is always there as the original authors of that IP work also ensures that beyond just the economic part, you're also getting what we call your moral right. That's the right to be recognized as the owner of those IP works. So that was kind of a long way to answer your question, but okay, I hope that answers all of your questions. Thank you.
Thank you so much,
Yes,
Mr.
thank you, sir. You more than answered it. I'm very grateful. Thank you very much.
Okay. Thank you so much, Mr. Max, for helping to tackle Oge's question. We have a second question in the chat box from Peace, and the question is directed at Mr. Olubanjo. She's saying that she didn't get the copyright aspects in your explanation. She's asking if that once your idea becomes tangible, it automatically becomes copyrighted, or you don't have to necessarily register anymore. Mr. Olubanjo, Mr. Adidamola, if you are still with us, would want to get your response to the question.
Sorry, please, can you come again? I didn't get that last part. Is it the
Okay.
response on the questions that was just posed with respect to the corporate personality and the co-founders?
No, there's a question for you that is directed at you.
Okay.
Yeah, the question is the piece is saying that she didn't get your explanation on copyright. She's asking if once your idea is tangible, once your idea becomes tangible, does it automatically become copyrighted, or is there any need to still register, or there's no need for it to still be registered?
Okay, so for copyright generally, you don't necessarily have to register. Registration is at your own discretion. If you feel the need to register, you register. But once you have created, once the idea has been properly expressed, is now in a form that can be seen, that can be heard, either as a literary work, artistic work, then it's already automatically the moral rights and the economic rights with respect to that work vest in the author. So you don't need to necessarily go ahead to register with the Nigerian Copyright Commission anymore. There's a presumption of authorship as soon as the work is created.
All right, thank you very much, sir. Do we still have any more questions? I think we can take maybe one or two more questions. If we have questions, we can still take, I think, one or two from the mentees.
Okay. Sorry, Dennis, while we wait, let me just add something to Mr. Adedamola's answer to the question from Peace. Just some practical aspect implications of what Mr. Adedamola said, which essentially is that when it comes to copyright, protection is automatic once your work has been, expressed or fixated in a permanent medium. You don't necessarily need a registration. unlike in patent, where without registration, you do not have protection. So you need to note that with patents. And then also there's another danger with patents that we always tell people. Now, in patent law, if you disclose the invention before you register it, you will lose the right to register it. That patent automatically, or that invention, sorry, automatically falls into a public domain. Anybody can use it. You yourself, you cannot restrain anybody from using it. So your competitors use it along with you. The reason why this is important for fintechs is that fintechs are always looking for money. So sometimes they create a new product and they want to, try to persuade, venture capitalists or angel investors or third parties to invest. So they just go to make a presentation, and you are, releasing all your container information, including patent. If you do that, or you create sample products and put them in the market, then automatically you lose the right to, to get protection for that patent. So what you must do is to ensure that even if you are going to release information to third parties, like you want to make a pitch to potential investors, financiers, and all of that, you should do it under the cover of a non-disclosure agreement. That way, you still have the right to register your patent subsequently, even though you have disclosed it. But like we mentioned, for copyright, automatically it is protected. However, the Nigerian Copyright Commission has what we call a voluntary deposit scheme. What that does is that you can voluntarily, at your discretion, register the deposit. Well, not register now, but deposit a copy of your copyright work with them. What that does for is that it shows evidence of your ownership. So if two of you have an argument and you're saying, look, I'm the owner of this copyright, I'm the owner of this copyright, the fact that one person can produce a certificate from the Copyright Commission would aid that person's case. Secondly, if both of us are arguing as to when it was created, and I'm saying, look, I've had this copyright since 2013, and I say I've had it since 2015. But if I'm able to produce a notification for a deposit certificate from the Copyright Commission showing that I deposited in 2015, then or in 2012, then it shows that I was first in time. But another practical way we advise startups is that even if you don't have the money to do copyright or to do the deposit, just to show evidence that you are the owner, when you write a source code, you can email it to yourself, so that way the timestamp on your Gmail or your whatever email server you're using can show when you created that work for the first time. That can also be an evidence, of course, not conclusive, but could be an evidence that, yes, since 2012, I've created this particular copyright work. Here's the evidence to show that I even emailed it to myself, or I emailed it to someone else, one of my team members. That can become evidence as well that you created that copyright at a particular point in time, even though registration, like we said, is not required. But these are just some of the practices that can be used as a part of the efficient IP management system in a fintech company. Yeah, thank you.
All right, thank you so much, Mr. Max, for giving more context to the question. We really do appreciate our mentors for their shared thoughts in today's class. It has been really, really insightful. For the mentees, well, officially we've come to the last session for the fintech industry class. Subsequent sessions are going to be across various other sectors, right? But we have officially come to the end of the last class for the fintech industry. So just before we go, right, we'll take our pictures quickly, and then, we will just bring a close to today's session. So for the mentees in class, can you quickly turn on your cameras? Let's take a quick screenshots or a quick picture, and then we would be going. All right, can we have mentees turn on their videos so that we can take a quick screenshots? Thank you, Anas. Thank you, Peace. Thank you, Sophia. Thank you, Chinemirim. All right, yeah, we are done with that. We've come to the end of today's session. We want to say a big thank you to our mentors, Mr. Adidamola, and also to Mr. Max Kombe. It has been an incredible journey coming from week 1 to this point, and I'm sure that we have learned significantly a few things about the fintech industry. So please, I want to kindly ask that, as a sign of solidarity to the session, for this final class, please let's make sure we post, right? Let's make sure we share, our thoughts about this session. You can do an overall post, right, to encapsulate everything that you've learned in the last 5 weeks. And do not forget to tag our mentors. Do not forget to tag Mr. Max. Do not forget to tag Mr. Adidamola. And then, you can always also connect with them on LinkedIn, and if you need to ask further questions and you need some help in some particular ways as regards the fintech industry, I'm sure that they are going to be available to, or they are going to be happy to help in any way that they can. Right. So once again, thank you everyone. For the mentees, don't forget to fill in your attendance. And yeah, we've come to the end of today's session. Goodbye everyone, and enjoy the rest of your day.